Now, we are concerned with the reference number 6, which says that sect of the Hindus. Now, the word Hindu has not been defined in the Constitution or any act relating to the Hindus. First time, my lord, a Constitution bench in 1966, Yogi Raj case, my lord, kindly have my written submission, my lord, or the notes which I have just passed on, my lord. Only one paragraph I will read, my lord. The Constitution bench 1966, it is, my lord, followed by the later benches, and in Sabrimala case, Justice Chanchud has also, my lord, relied on this judgment. Now, kindly see, my lord, what the court says. It just, my lord, I'm reading the relevant paragraph. It does not claim any one prophet. It does not worship any one god. It does not subscribe to any one dogma. It does not believe in any one philosophical concept. It does not follow any one set of the religious rites or performances. In fact, now, my lord, it is irrelevant. In fact, it does not appear to satisfy the narrow traditional features of any religion or creed. It may broadly be described as way of life and nothing more. Now, kindly see, my lord, the first time the definition of the Hindu has been attempted to be made by the Constitution bench. With great respect, I submit, my lord, this definition is not correct, and it is being followed by the later benches, and Justice Chandrachud has also followed it. Now, kindly have, my lord, one relevant paragraph of the Keshwanand Bharti case. I have extracted it. Paragraph 651 of the Keshwanand Bharti case, where, my lord, a very beautiful example has been given of the religion and the Constitution in regard to the basic feature of the religion and basic feature of the Constitution. Only one paragraph, I will hurriedly read it. Our Constitution is not merely a political document. It is essentially a social document. Like every religion, it has two main features: basic and circumstantial. The former remains constant, while the latter is subject to the change. The core of the religion always remains constant, but the practices associated with it may change. Now, my lord, I pause. Now, my lord, this case says that the religion has also two my lord, compartment. One, basic features, and another circumstantial, which goes on changing. So the earlier division of our Constitution bench, which says that it is way of life, with great respect, I say, my lord, it is not correct. Now, the question arises, what is the core of the basic feature of the Hindu religion? You know, this attempt has been made several times, but no one has successfully propounded that what is the Hinduism, because your lordship is hearing, your lordship has heard enough on this subject. My respectful submission is slightly different. This nine-judge bench cannot attempt to make a definition of the Hindu by taking the advantage of the Bhagavad Gita. Bhagavad Gita came much before these, my lord, the essential practices which have been, my lord, described before your lordship. Now, the Gita is safe for two reasons. Number one, a large number of the commentaries have been made on this subject, and there is no conflicting view on the Bhagavad Gita. Otherwise, in the Upanishad, Vedas, and all these Smritis, if we go, there is a lot of conflict. Reason why there are different practices in the country, and so one core Hindu religion cannot be, my lord, defined except the aid of the Gita. Now, my lord, kindly see, I will cite only two verses of the Gita, which shows that our Constitution, the fundamental rights, and some other philosophy has been taken from the Gita. Now, my lord, kindly have my notes, my lord, chapter 5, verse 18 says, my lord, I'm reading only English translation. The wise see with equal vision a learned and humble Brahmin, a cow, an elephant, a dog, and even an outcast. So Article 17 of the Constitution is very much there in the Gita itself in chapter 5, verse 18. Now, similarly, Lord, the equity we can found chapter 9, verse 32. which English translation says, my lord, O Partha, even those who are women, Vaishyas, Shudras, or sinful birth attain the supreme goal by taking refuge in me. So these, there are several other, but due to lack of time, I'm not citing those. I have mentioned all these, my lord, in my written submission, which is at 1.3, volume 1.3. Now, my lord, kindly see, my lord, the Hindu word, which we have been told that it has come from the foreigners, because the people who are living across the Sindhu, they are called Hindu. Now, kindly have my written submission, my lord. Just, my lord, last paragraph, I will not read further. Hindu. My lord, the Chinese traveler, who came much before 3 EC, he says that these people are the Indus. He found this word Indus from the moon, because the synonym of the moon is Hindu. Now, since Lord Krishna in chapter 15, verse 15 has said that I live in the every living being's heart. So the Chinese traveler says that these people who are living beyond, who are living in this country, they are governed by their heart. And three word he has taken from heart. So he says Hindus. And later on, these foreigners have taken this word and has redefined is that the people who are living beyond the Indus are Hindus. This definition has come much before the foreigners has given this definition of the Hindu to us. That's all, Lord.
Thank you, Mr. Vaghela. Thank you. Thank you.
Yeah.
Thank you.
May I with
Para
my
F, I may not kindly have the para F of my written submission. I'm not reading it.
Thank you.
May I, with my lord's leave, make my submissions, my lords? I'm in 901.54, representing the Akhila Bharatiya Ayyappa Seva Sangam, my lords.
Come to the mic side, madam.
I will make two submissions and one pertinent clarification, my lords. My first submission is this, my lords. Across religions, in the path of devotion, every religion prescribes this adherence to austerities or vrata as an effective tool for God realization or liberation, my lords. You know, every vrata has its own set of yama and niyama, that is do's and don'ts, my lord. Insofar as the Sabarimala vrata is concerned, every devotee who desires to have the darshan of the Lord must adhere to austerities for one mandala, which is 41 days. And thereafter, he becomes eligible to carry the Irumudi, which is the holy offering to the Lord, and then only ascend the holy 18 steps, my lords. It often happens, my lords, that even men who have undertaken the penance, my lords, during this...
Pass on what you are saying.
Oh, sir, I'm so very sorry. I'm so very sorry, my lords. Even during observing the vrata, my lords, what happens is if a man loses his, unfortunately, parents or wife, my lords, he has to necessarily stop the vrata. The holy Tulsi Mala that he takes on the initiation of the vrata, at the inception, he has to give it up, my lords, and his vrata comes to an end. Therefore, my lords, my humble submission is this, that the niyama of the Sabarimala vrata mandates that any devotee who is desirous of the darshan of the Lord must undergo this 41-day period vrata, my lord. So any person who is not able to fulfill this vrata, regardless of a man, as he will, when in situations when he loses his parents or wife, my lord, they cannot be permitted to enter the shrine. Therefore, my lords, my respectful submission is, if the petitioners, the women, are allowed entry, that would amount to modifying or in fact destroying the yamas and niyamas of the vrata itself, which cannot be done under 25(2)(b) or any other state action, my lords. My second clarification, my lords, is much has been said about sati. I have with my, my lords, compilation, annexed the Bengal regulation of 1829, my lords. I would only read the opening paragraph of the regulation itself, my lords, which is at page 23. If my lords may kindly have. Page 23 is section 1 of the Bengal Sati regulation 1829. My lord, this categorically declares The practice of sati or of burning or burying alive of the widows of Hindus is revolting to the feelings of human nature. It is nowhere enjoined by the religion of Hindus as an imperative duty. So it was never a religious practice, my lords. And then 4 lines thereafter, these acts of atrocity have been perpetrated, which have been shocking to the Hindus themselves, and in their eyes, unlawful and wicked. So even to the Hindus, it was unlawful and wicked. My last submission, my lord, is I would respectfully draw my lord's attention to the revered author, H.M. Sirvai's critical analysis of the Constitution of India at page 5, my lords, paragraph 12.41, where, while dealing with the rights under 2526, the learned author says, again, the violation of a right to enter a denominational temple has to be judged in the context of the law under which the right was claimed. My lords, over the page, the learned author refers to State versus Puran Chand. Over the page is a case which arose in the year 1950s, my lords, when Puran Chand is the pujari of a Jain temple. He did not permit a Dalit, Hindu Dalit, to enter the Jain temple, my lords. Therefore, he was sought to be prosecuted under the Untouchabilities Offences Act 1955. Having regard to the language of Section 3 and the explanation, which says that every Jain is deemed to be a Hindu, the question arose as to whether he has committed any offense. The trial court convicted him, but the appellate court, my lords, over the page at page 7 is very relevant, my lords. Para 2, last 3 lines. The learned sessions judge interpreted the explanation differently, holding that, according to the explanation, although Jains would be treated as Hindus, Hindus could not be treated as Jains. My lords, in the last paragraph, the complainant in this case is a Hindu, and therefore it was necessary for the prosecution to establish that the particular temple was open to non-Jain Hindus in general. The argument advanced by the learned government advocate that a temple exclusively open to Jains should, in the light of explanation, be deemed to be open to Hindus in general, and Harijans should be admitted in such temples does not appear to me to be correct. The object of the provision is not to create any new rights in favor of untouchables, but it is intended only to put them at par with other caste Hindus. Drawing analogy from this, my lords, my respectful submission is, if the writ petitioners are believers, such as the devotees who are the review petitioners before my lords, if they are standing on the same footing, my lords, number one, they would not and should not question the yamas and niyamas of the Sabrimala Vrata if they are believers. And if they are non-believers, they don't, as a matter of right, claim entry into the temple, my lords. That is all, my sir.
Thank you, Madam Shobha. Thank you. Thank you.
May I please, your lordships? I am appearing for All Kerala Brahmin Federation, which is a review petition of my lords. Lordships, may kindly, I'll not take much of your time, lordships. Kindly have a look at the structured submissions, my lords. Yes, please. May I first, I'm Abhilash, I'm appearing
2
for
minutes, sir.
just 2 minutes.
Just follow like Madam Shobha has been very brief and to the point.
Yes, my lords.
Thank you.
My ladyship had raised a question, my lords, as to what precisely is the sui generis nature of Sabrimala temple, though the learned solicitor had responded at that time by virtue of me hailing from the same taluk where the temple is situated. Let me make a short submission, my lords, that Sabrimala temple happens to be the final hermitage of Lord Ayyappa. In other words, my lords, Ayyappa is theologically believed to be residing in Sabrimala temple. Unlike all other Ayyappa temples, his physical manifestation is a religious presumption. My lords, apart from that, there is a specific place named Mani Mandapam, which I kept as appendix, a photograph, my lords. Mani Mandapam, which happens to be the Jiva Samadhi of Lord Ayyappa. On account of all these reasons, Sabrimala temple happens to be sui generis on account of the theological faith that Lord Ayyappa resides there. Lordships, kindly have a look at the first question, which I have discussed, my lords, on page number 1. What is the meaning and scope of the expression? All persons are equally entitled under Article 25(1) of the Constitution of India. In my humble submission, this is an aspect which has not yet been dealt even under Shirur Mat, my lords. I'll take your lordships through the submission. It is respectfully submitted that the Constitution draws a clear and substantive distinction between the expression all persons in Article 25(1) and every religious denomination or any section thereof in Article 26. The use of the expression all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion implies in clear terms the right conferred as an entitlement to all persons to practice religion. In other words, rights available to a person shall be exercised in such a manner that the equal entitlement conferred on others shall not be affected. A single person cannot constitute a religion, and it is essentially meant for a group of people in case of a place of worship. Hence, any claim of entry to a place of worship following a distinct set of rituals and practices like Sabrimala can be recognized only in consonance with the customary practices associated with the deity, because entitlement is equal to practice religion. It is submitted that Part 3 of the Constitution confers rights on 4 categories of people for the purpose of classification: person, all person, citizens, all citizens. A chart of classification of rights conferred under Part 3 is presented herewith. Kindly have a look at page number 2, my lords. I have classified rights conferred on person, all persons, citizen, and all citizens. And Article 25 happens to be the only right, my lords, which is conferred on all persons. Thereby, meaning when a person is seeking to exercise his right under Article 25, it shall have to be necessarily exercised in consonance with the rights of other members of the community. Article 26 talks about every denomination, whereas Article 25, 1 is categorical and clear that all persons are equally entitled. In my humble submission, it's essentially a collective right. While protecting the right of every single person, it shall have to ensure, the right ensures that right to practice religion is protected. Lordships, kindly have a look at question number 2, my lords, whether the enabling power under Article 25(2) of the Constitution can be invoked to justify actions by state authorities that result in violation, dilution, and destruction of long-standing customs and usages integral to the religious practices of a temple. Lordships, I understand that this happens to be the greatest deliberation on Article 25 since Constituent Assembly debates got concluded. The scope of Article 25, when your lordships are deliberating upon, may necessarily have a glance, may necessarily touch upon this aspect, my lords. Quickly, I'll read. It's respectfully submitted that Article 25(2) of the Constitution, which enables the state to regulate secular activities associated with the religion and to enact laws for social welfare and reform, cannot be construed as conferring any authority upon the state or its instrumentalities to violate, disregard, or destroy the established customs and usages of the temple. The provision is enabling in character and operates within the constitutionally defined limits. It does not authorize administrative authorities to act in derogation of the rights of the believers under Article 25(1) of the Constitution of India. For instance, a political party having atheistic ideological foundation may ascend to power in a state and may appoint a non-believer as Devaso minister or official. The state minister may, despite strong atheistic belief, step into the temple premises or in front of the sanctum of the temple where religious activities are performed and can act in a manner irreverential to the customs and practices. The person holding authority under the state may stand in front of sanctum and stare at the sanctum without any customary salutation, or may receive holy water from the sanctum offered as prasada and may pour it down on the floor or may dispose the holy water with irreverence. The question that arises here, my lords, is whether the right under Article 25(1) extends also to the extent of protecting the sacred practices and customs from state intrusion under the guise of authority under Article 25(2)(a). This may be answered by issuing appropriate guidelines or observations. Lordships, kindly have a look at page number 5, my lords, whether the exclusionary practice in question based on the concept of youthfulness is based on the concept of youthfulness of women rather than the notions of fertility. It was advanced by senior counsels who argued previously that the notions of fertility is significant here. Because of me hailing from the same place, my lords, after having been associated with this practice for quite long, it's not fertility but youthfulness, my lords, that is fundamental. Lordship, may kindly have a look at page number 6, my lords, whether for the purpose of Article 26 of the Constitution of India, the existence of a formal structure such as organization, endowment, etc. is necessary precondition for recognition as religious denomination. The issue is very much answered, my lords. I am not further touching upon that. Nevertheless, my lords, there are 2 examples. One is that of Naga sannyasins, which form a very loose conglomerate There are different akhadas or monasteries, my lords, which are associated, which are organized under the general name of Naga Sannyasis, like Niranjini, Juna, Nirmohi, Udasin. These are all monasteries, but there are such practitioners who are not formally classified. Nevertheless, they claim their distinctive legacy and they also deserve protection without being formally organized, my lords. Likewise, there is a Sampradaya named Nath Sampradaya, which happens to be a very broad theological set of practices and beliefs. And under Nath Sampradaya, there would be certain organizations like Self-Realization Fellowship, like that of Paramahamsa Yogananda. But there are large number of, I myself am an initiated disciple of that particular sect, but there are large number of practitioners of Nath Sampradaya who are not formally organized. On account of the peculiar practices, they also deserve protection, my lords. Then your lordships, if may come to page number 8, my lords. Is Sabarimala a Hindu temple in the light of the people belonging to other religious communities offer worship here? This was advanced by Learned Senior Counsel Gopal Shankaran Narayan. He stated that Sabarimala is not a Hindu temple, but just let me take through that provision, my lord. Sabarimala is a statutorily recognized as a Hindu temple under Travancore Cochin Religious Institutions Act of 1950. Sabarimala temple is included under Schedule 1 of the Act as ordained under Section 2C that provides for incorporated Devaswams. That means Devaswam mentioned under Schedule 1. Hence, the eclectic nature of worshippers in Sabarimala does not denude its essential character of being a Hindu temple. It is also submitted that over 95% of the pilgrims in Sabarimala belong to Hindu religion. Lordships, my detailed written submissions are there. I'm highly grateful that your lordships
Thank you, Mr. Villan. Thank you.
heard me.
Lordship, I will not take
Spell your name
more-
also so that, sometime.
Lordship,
Yes, you.
my name is Dr. Shayan P. Shashidhar. I am for Akhila Bharatiya Malayali Sangh.
Yes, please, quickly.
Lordship, I restrict to only indigenous people and it's related to 25 and 26, which so far nobody is addressed that part. Lordship, there is more than 700 indigenous people or ethnic groups are there in India. And these entire ethnic groups got their own belief system. And they are addressed as Adivasis, Girijan, Vanvasi, Giri Varg in multiple names. But our constitution identifies them as only scheduled tribe. And the scheduled tribe definition is there in 366(25). Read along with Article 342, and also it should be read along with CO 22, which is called Scheduled Tribe Order of 1950. But Lordship, if we keep all these things together and read, then also the scheduled tribe definition is ambiguous. And this honorable court in multiple instances, multiple judgment, it is being directed to the government that make a unambiguous definition for scheduled tribe. Lordship, this ambiguity which is coming because of the term tribe. Our constitution, it's more than 40 times it is repeated in tribe the term, but it is not anywhere it's clarified what is a tribe. And this tribe word in multiple instances, multiple judgments, this honorable court bring it into a definition form, which is started with a state of Kerala versus Chandra Mohan, which was the initial, that was on 2003 judgment. It was a 3 judges bench. In that one, common delight and cohabitants, etc., were the main characteristics of this tribe, which is. And Nyayagiri judgment, one of the important judgment, it is a 3 judges bench again. It is also called that Orissa Mining Corporation Limited versus Ministry of Environment and Forest and others. This judgment was on 2013. And Lordship, the recent judgment, which is of 1 month back, Justice P.K. Misra and Justice Manmohan bench, which is, there was one judgment which is called Chindada Anand versus State of Andhra Pradesh.
What is the
This is
approach?
even cemented the tribe, what is tribe, to bring a definition for the tribe. Lordship, what I would like to say is, tribe is a tribe because of their practices. Lordship, the practices which are of three type of practices. One is cultural practices, customary practices, and ritual practices, or we could say that cult. Cult in the sense it's of traditional practices as well as ritual practices. These whole three together, these three practices comes through together, then only a tribe become a tribe. That's what this quote itself is saying, and that is, I agree with that point. Lordship, about the tribe, it is not only a constitutional obligation, there is an international obligation also for India. See, there is various convention and submits which I mentioned in this one. That's on Earth Summit 1992 and Biodiversity Convention, which is in again 1992. And
What do you want to say, submit? What is your ultimate
Argument with reference to
practice which deals or which identifies a tribe.
practice? It defines a tribe.
Yes.
Therefore, that should not be disturbed.
These practices are, my lord, these practices are connected to the faith. These practices are connected to the religious system.
I understand.
Okay, my lord. So this one is essential practices theory, which cannot be applied to this tribal perspective.
Understand,
Okay.
understand. That your argument is.
And one more, but just one point. And comes to Article 371A, which is a special provision which is given to Nagaland, state of Nagaland, which clearly states that notwithstanding anything in this constitution, no act of parliament in respect of religious or social practices of Nagas, Naga customary law and procedures, Naga administration of civil and criminal justice involving decisions according to Naga customary law. Lordship, what is my doubt, I ask myself, is when one organ is restricted from interfering into the customary law or customary practices, whether another organ, whether could involve into or interfere into that particular practices. This is what my...
Thank you. We understand. We appreciate your argument.
My lords, I'm arguing from the lens of self-determination, and I'm arguing from the lens of self-determination in Article 25 and 26. There's a 2-page note on self-determination that I'm transferring. This is for, what is this? And this is for this side, my lords. There's a 2-page note on that new proposition of self-determination. I would just request my lords to take note of that. I'll start my submissions, my lords. The Constitution of India is a single most extensive statement of self-determination made by a sovereign state in known history. Through our founding mothers and fathers, we the people in Article 25 and 26 also encoded covenants in Article 25 and 26 describing and determining our religious identity. If my lords were to look at the Hindi Constitution of Article 26, religious denominations is called Pratyek Dharmik Sampradaya ya uske kisi anubhag. This definition is wide enough that on one hand, it protects formal worship as seen in the Ramakrishna Mission case, and on the other hand, it protects those indigenous practices and unique practices of worship of Prakriti and nature as seen in the Niyamgiri Hill case. Unlike the present understanding of denominations which we see in a formalistic sense, the determination of religious practices, my lords, has evolved in 6 phases. What started from Shirur Mat and Ratilal Panchanand on essential religious practices has now reached constitutional morality in this case. Point number 4 of my submission is that evolution of the law and the cases mentioned. This expansive reading, my lords, I submit, has reduced the right and denuded the right of the community to determine its own practices, which has been recognized in Shirur Mat and Ratilal Panchanand, thus requiring reconsideration to bring it back to the hands of the community. This reconsideration, however, does not preclude judicial intervention, judicial review, and also does not restrict or make Article 26 absolute, as we've seen in the Constituent Assembly debates also. And is subject to regulation. This extensive reading into the silences defeats the text when we see it from a lens of self-determination. And this needs preservation. However, my lords, I do emphatically submit that the intent and conclusions of Venkatramana Devaru ought to be upheld and preserved and protected. Now, my lords, to this extent, the conjoint reading in SP Mittal, unlike Shirur Mutt, which was disjunctive in nature, upholds the narrow state jacket view of denominations. This precludes a protection that would otherwise be granted to indigenous communities and people. Similarly, my lords, in Article 25, when we look at the term section of Hindus, it reads as Hinduo ke sabhi vargo or anubhago ke liye. This, my lords, has to be seen in light of its historical context and cannot be seen in light of gender, because if seen in light of gender, it would also affect and denude practices of those spaces that belong exclusively to the feminine and the third gender, which is governed by their respective rituals. Now, my lords, before I progress, just if your lordships could look at my note in footnote number 2,
Yes, continue.
there is an explanation to other secular activities, my lords,
Continue.
that comes from the Dakor temple case,
Yes.
which had shown what secular really means over here. So if an argument is made that secularism should be seen in Article 25, that would not cover within the ambit of Article 25(2) and other secular activity. This last to say, my lords, this honorable court is providing a judicial nuance to this encoded self-determination. This will reflect the constitutional promises made to communities and for generations to come. I'm grateful for the
Thank
patient
you,
hearing,
thank
my
you,
lords.
Rahul, thank you. Yes, please, yes,
Grateful.
yes, yes.
Thank you.
Yeah.
I'm Krishna Raj, my lord.
Sama.
I'm Advocate Krishna Raj, my lord. Item number 901 point,
Take 2 mics at least. We could do that.
my lord, I am Advocate Krishna Raj, my lord.
Thanks.
I'm representing 901.62 and an intervention application.
Yes, please. Yes, yes, please.
Lord, I passed on the notes. Two copies are there. Volume 1 and 2. Volume 1 and 2. My lord, the
वो आगे सर्कुलेट करते हो तो यहाँ रख के बैठ जाते हो. Yes, please start.
Yes, my lord, the first point is, my lord, about the civil right of the deity. Lord, what I'm civil right of the deity, my lord. My lord, it's an admitted fact that the property wherein the temple is situated, Sabrimala temple, my lord, belongs to the deity, because in all the revenue records, admittedly, it is recorded as the property of Sabrimala Devaswam. Now, Devaswam means property of the Devan, deity. So, my lord, property belongs to the deity. So, my lord, as a juristic person, in the 5 judges bench, my lord, there is a discussion to the effect that, my lord, even though the deity is a perpetual minor considered as a juristic person, there is, since it's a fictional character, my lord, there cannot be any fundamental rights. My lord, that's why yesterday or day for yesterday, lordship has asked about application of Article 21. So, my humble submission, my lord, as far as the deities are concerned, it's a prana pradishta, my lord. In my compilation, my lord, I have clearly, my lord, in paragraph 5 onwards,
Yes.
volume 1, my lord, 5 onwards, I have clearly, my lord, mentioned all the prescriptions of construction of a temple and installation of a deity, including it starts from the selection of a property, because even each and every property emanates, my lord, energy, whether it is positive or negative. It starts from there, and ultimately, my lord, it covers paragraph 7 and 8. And when it reaches, my lord, paragraph 9, my lord, and paragraph 10, it explains the prana pradishta, how a deity is installed, my lord. My lord, may I just read, my lord, paragraph 10, 2-3 lines. Lordship has got it, my lord. After the material for the deity is selected and the idol is made, the procedure for consecration starts. At the time of the installation of the deity, the tantri of the temple will give life to the deity from his own body through the mantra which is selected according to the bhava of the deity.
Proposition. What is the proposition?
Proposition, the deity is a living person, because we are giving food to the deity 3 times a day. So deity is a living person, and therefore, my lord, deity has got a constitutional right as well as a civil right. So as far as civil right is concerned, my lord, deity has got a right to decide whom to enter the property. He can select the persons. So, my lord, the wish of the deity and will of the deity is determined by, my lord, the Deva Prashna. It's a ritual called Deva Prashna. There are 3 Deva Prashnas wherein the wishes of the deity is clearly stated. It's clearly stated that, my lord, the women. Then as far as the ritual is concerned of restricting the age group, my lord, I have stated, my lord, in paragraph, first may I have kindly have a look at paragraph 13. It starts from paragraph 13. Because each and every, my lord, there are 18 steps reaching, that's called holy steps, my lord. No, what I'm saying, my lord, the ritual is nothing to do with, my lord, this menstruation. That is what I'm saying. What I'm submitting is, my lord, the 18 steps of, my lord, is each one, every ritual of human being, my lord. When you enter the steps, my lord, the virtues are dissolved. And when we reach the temple, my lord, it is called Tattvamasi because we are laying with the deity. So then Lord, may I have a glance at volume 2, the intention of this entire process. Lord, may I have a glance at paragraph 7.
We are not going
Lord,
to
after not merit. Regarding the locus, regarding locus, my lord, locus. My lord, the entire issue started from Shabarimala. That's why, my lord, there is a speciality of the temple that's submitted. Now, Lord, may I have a glance at, my lord, the volume 2, my lord.
Your submission when we take up the main case.
I understand. Just one submission. My lord, after the judgment of the 5 judges bench, my lord, there is permission for the ladies to enter the temple. And there was even after on the reference made to this bench, my lord, there was no stay. Only, my lord, 2 ladies entered the temple with the help of the police. And, my lord, there were attempts to enter the temple by another 3. My lord, I have given an entire list. All are declared atheist. So the intention is very clear. The intention is very clear. My lord. There are not, my lord, declared atheists. I have given the description of the entire people.
All right, thank you, Mr. Krishna. Thank you. Thank you very much. Thank you.
Please, Your Worship. I'm appearing in 966. This is the matter where entry of Muslim women in the mosque is being regulated. My Lordships, 2 facts. Firstly, the mosque in question is merely a public trust. It's a public charity. So it won't be amenable to a writ jurisdiction under Article 12. That's the first proposition. Second proposition, we as a regulator of Waqf Board cannot interfere into their domain, cannot interfere into their religious affairs. So that's the second proposition. Now, the petition actually is canvassed as if to say that it's the obligation or the right of a woman to go and offer namaz in a mosque. Now, what that would happen is, Your Lordships, I have carved out in my submissions, page number 4, I have juxtaposed Muslim males' obligation to perform namaz with the privilege of a Muslim woman to perform namaz. Could Your Lordships come to that? Page 4.
Yes, please. You can.
I've said that Muslim male.
It's true now.
Well, I'm just
Confine yourself to only 7 questions raised here, sir.
but based on this, I'll come to it. What I'm saying is that a compulsion on a husband or a man cannot be made as an obligation on the woman. If we were to say that she has to go, we will actually be saddling her an onerous task which her religion does not. Now, with that, Your Lordships.
What is the prayer in this petition?
The prayer in the petition is that Muslim women should be permitted to enter the mosque. That's the first prayer. Second, the prayer is that they should be allowed to perform namaz there. Now that they themselves admitted that it's not prohibited. But if we were to allow something like, who would regulate it? Either Union of India, state or Waqf Board would regulate it. Now we cannot be directed by a writ of mandamus to do something which constitutes prohibition.
We understand well.
But second proposition that I'm giving Your Lordships is that in every matter where a writ is sought, or in every religious matter where an intervention is sought against a non-state entity, every such PIL should be relegated to 92, say read with section 9, 15 and section 26 of the CPC. 15 says present the plaint before the lowest competent court. 26 says file a suit by presenting a plaint. And in that plaint, expert evidence along with all issues can be done. The expert can be voir dire. Whether he is an expert or not, that can also be tested. So that second proposition that I'm giving, that the suit is the way that should go. But the last proposition that I'm making, it's a bit bold. But if Your Lordships would turn to page 12, I'm saying as a policy of judicial restraint, this court may take a call,
Well argued,
But what I'm telling is that we are to draw a presumption whether an act is constitutional or not. Now 25 uses the word entitlement. The opposite of entitlement is deprivation. So if something was available to me and I was entitled to it until yesterday, and if it has been denied to me or
Right.
deprived today, then the legislature should come and explain how the entitlement has been taken. So the proposition that I'm making is that one who interferes and disentitles should prove that his legislation is within the constraint of 25 and 26. But lastly, there can't be any privity or parity with Sabrimala. Last I'm saying is that all this institution, this Waqf institution and temples, all are left to fend for themselves. They are not sponsored or granted because we are a secular nation. We can't fund an institution directly except somewhere laws have been passed or they have been enacted that way. Because all that I'm saying is that it will be a travesty that whilst we can't give them any, that's money, we can't give them any, we won't let them have any, that's freedom. If you can't give them money, at least let them have their freedom. Because I'm grateful.
Thank you.
Obliged.
Please see it.
C. Rajendran.
All right, 2 minutes, please, sir. Huh?
Yes, my lord. My definite case is that, my lord. This temple, this was not a Hindu temple. It was a Buddhist pagoda. My lord, the name Shibir is training. Shabarimala is a training center for the Buddhists on the top of the hill. Thus, it became known as Shabarimala. But is the Dalai Lama's palace is also named as Shabarimala. Your Lordship, may kindly say, there are 60 to 70% of the Keralites were Buddhists, my lord. Thereafter, the advent of the Vaishnavism and the Shaivism and also Bhakti Prasthanam by the Shankaracharya, all the Buddhists were wiped away from the Kerala. My lord, that is but this was being on the top of the hill. My lord, it remained there. Your lordship can see page 3. It was a Buddhist pagoda.
Yes.
My lord, later on, it was converted into a temple. Second page. And the third picture shows it was converted into a Pakka temple by flag posts, etc. My lord. There are two types of temples in Kerala, my lord. Samadhi Pidams and Prana Pradishtas. Prana Pradishtas, the prana of the person who is giving it is transmitted to the idol, and the idol becomes a living person. But the most powerful is the Samadhi Pidams, my lord. That is a contemporary of Lord Ayyappa entered into Samadhi. A picture, your Lord may kindly see, page 6, my lord. His name is Sang Tansin, who entered Samadhi.
Yes, yes.
My lord, his body was mummified there. And in the 2004 earthquake, it came out for. Now that is why we will get the port. Your Lord may kindly see the picture of Ayyappa. This sitting a poster of Ayyappa as well as this Buddhist is same, my lord. This sitting of Ayyappa is known as Pattabadhasanam. But my lord, the practitioner is generating heat in his body, and for not losing it, they are sitting either on the skin of lion, deer, etc. Here, Ayyappa is sitting without touching his buttock or anus in the ground, so that the practices generates heat for the awakening of the Kundalini and push it up to the Sahasradala Padma. Then only the man comes to the stage that I am Brahmasmi. That is another aspect. So my humble submission is, this is a distinct Buddhist temple, and there was big rivalry between Vaishnavis and Shaivis. And in order to coordinate them, a story had been built up that Ayyappa is the son of Shivan as well as the Vishnu, and he has been given a name Harihara Putra. This is the manipulations where
We are not going to this issue, Mr. Rajendran, right now.
It stands on a separate distinct denomination, and menstruation is not at all a stigmatic And it is a divine process in Kerala. It is stated that menstruating women are moving gods, walking gods. So your Lordship, my humble submission is the real nature of the temple has not been brought up, and the Mahendran.
All right, thank you.
So my submission is that the right of the devotees of Ayyappa may be kept open for agitating before the Honorable High Court.
Thank you.
That Mahendran case is-
Thank you, Mr. Rajendra. Yes, madam.
I'm Advocate Usha Nandini, and I had assisted Mr. Gopal Shankaranaran as well as Mr. Jain Mudraj in other two matters. And being a devotee, I had separately filed an intervention application in the main petition and separate review petitions. This is in 901.31, wherein Mr. Chidambaresh has filed a separate written submission, and these submissions are in addition to that. Kindly see, Your Lordship, the present submissions are confined to only question number 3 and 7 in the reference. I am not looking into the other questions. The first one is whether the rights of a religious denomination under Article 26 of the Constitution of India are subject to the other provisions of Part 3 of the Constitution for India, apart from the public order, morality, and faith. And the answer is no. Kindly see, Your Lordship, the framers of the Constitution consciously omitted the word subject to the other provisions of Part 3 in Article 26. And the rights of the individual under Article 25(1) are subject to public order, morality, and public health, as well as to the other provisions of Part 3 of the Constitution. And this necessarily includes Article 26. And at the same time, the rights of a religious denomination or a sect thereof, which may include a group or community, under Article 26 are subject only to public order, morality, and public health, and not to the other provisions of Part 3. Kindly see, Your Lordship, then the diversity of religious practice vis-a-vis religious denomination under Article.
Make out your point that we will read, madam.
Your Lordship, only one
Name is
paragraph.
not there now. These are all extra burden on us.
Kindly see, Your Lordship, the seventh question. There is a question that whether a person not belonging to religious denomination or religious group can question a practice of that religion. And the answer is also no, Your Lordship. And a person who neither professes the relevant faith nor participate in the associated practices has no right, whether constitutional or otherwise, to challenge such practices on the ground that they conflict with their own values and beliefs. And Your Lordship, another point is, Your Lordship, regarding the bill filed in Sabrimala. My submission is, Your Lordship, it's like forum shopping. Because kindly see the statement by
Very well. That has been argued in detail.
no, Your Lordship, the thing is that see, all the petitioners, they belong, they are from the NCR region only, and that is the only reason they had preferred the writ petition under Article 32 instead of approaching the Kerala High Court under Article 226. And I can say that it's not a public interest litigation, it is a publicity interest litigation only. That point may also be considered, and Your Lordship may. Now, Your Lordships are poised to deliver an authoritative judgment in Articles 25 and 26. And at the same time, I request Your Lordship to frame some guidelines for considering this kind of public interest litigation, Your Lordship. That's all, Your Lordship.
Thank you. Thank you, madam.
Please, Your Lordship, my lord, I'm Prachi Vajpayee. I'm appearing for two petitioners, my lord. There are two petitions are there. The first one is for the temple, which is Ayyappa temple, which is 5,000 years old and is owned by a family. And following the same rituals as it is in the main temple is there. The another petition which, my lord, I have filed is for Samasthanayar Vanita Samajam, that is a woman wing. So, as far as Your Lordship has framed the questions, and we are here for discussing those questions, my lord. The
Take
first,
the mic also yourself.
my lord,
Yes. Yes.
Both the mics with you. My-
Take both mic.
yes.
Use your full voice. Very
My lord,
quickly.
the first question Your Lordship has framed, that is regarding the scope of the Article 25, my lord. My lord, we know that every freedom and every article of freedom is subject to some conditions, and the Article 25 is not an exception to that. The another question Your Lordship has framed regarding the interplay of the Article 25 and 26. My lord, there is a saying that my right and freedom to swing my hand ends from where the others' rights and freedom starts. So it should not hurt the others' freedom and right, should not infringe. As far as the Article 26, whether it is a part of, subject to part of other articles in Part 3 or not. Well,
Yes, correct.
so we have to, as Your Lordship has held in many judgments, that we have to adopt a harmonious construction of interpretation, and every article and intent of the constitutional framers has to be given a meaning. Because if we give importance to the one article and the other is subserved, then we will not be, rather we will be denying the intention of the constitutional framers. As far as the question regarding the morality is concerned, my lord, the constitutional morality is nowhere mentioned in the plain reading of my understanding. Nowhere it is mentioned in the constitution, and framers could very well use that word constitutional morality, but they have not intentionally. So in that article, the word morality is used, and we should take it as a morality simpliciter in the context of that article, which is focusing on the religion, my lord. So we have to see the morality from the perspective of the religion. And even the judicial interference is also only should be unless until it is so much required by your lordship, and then unless it is so much against the humanity, which cannot be which cannot be a person cannot which cannot be avoided, my lord. I'm sorry. And as far as the word section is mentioned in the Article 25B, my lord, it is we have to see from the perspective of the Article 17, which is clearly it is regarding the excluded class, which were not allowed to enter, and the temple after the independence, the temple were the entry was given to the excluded class. My lord, the persons who are not belonging to the denomination, they should not challenge the rules, as we know that our rights only limits to that others' rights should not get infringed. So individual right is my specific right, which ends to the practice, what practice I follow. Well, the moment I join the institution, it should be subject to the rules framed by the denomination or the institution.
Thank you. Thank you.
Madam, we didn't get your name.
Maybe.
Madam, can you tell, we didn't get your name, madam.
I am Atulesh Kumar, my lord.
Madam.
I'm Prachi Vajpayee, my lord.
No, thank you.
My name is in the list.
Oh, thank you.
Lord, I am appearing for Akhil Bharatiya Sant Samiti, my lord. IN number 98855 of 2026, my lord. I am Atulesh Kumar, my lord. My short submission, my lord, I will not take much, more than 2-3 minutes, my lord. My lord, submission on the issue of scope and extent of the judicial review with regard to the religious practice as referred to in Article 25 of the Constitution of India, that is reference number 5, my lord. To substantiate my point, my lord, I would like to give 1 or 2 examples, my lord. So for religious practices as concerned, my lord, where I have given the example, my lord, of 12 Jyotirlinga, my lord, in which specifically one Mahakala temple where Bhasmarti is performed. All 12 temples of all Jyotirlinga is the manifestation of Lord Shiva. But so far as Kaleshwar temple is that, my lord, their Bhasmarti is performed. That Bhasmarti is not performed with other Shiva temple. That is the religious practice followed, my lord. So far other example are concerned, my lord, 51 Shakti Pithas are there. But Kali temple in Calcutta and my lord, one more temple in Kamakhya temple, the religious practice are totally different. My lord, there are 3 types of temple I have mentioned in my 4 pages note, my lord. Private temple, that is Griya or home temple, social temple, and Tantra temple. I will skip, my lord. I will skip, my lord. And so far as my submission on the Sabrimala temple is concerned, my lord, this restriction between 10 to 50 is not violative of Article 14 of the Constitution. My submission is, my lord, because there is no absolute restriction, my lord. Is prior to 10 and then post 50 it is allowed. So there is no restriction, absolute restriction. Therefore, we cannot say this is violation of Article 14 of the Constitution, my lord. And I can give the example of, my lord, Article 19, what freedom of speech and expression subject to Article 92. My lord, the essential religious practice doctrine has developed by the court in Surur Mat case, my lord. In Sabrimala, my lord, in 5 judges bench, the gender equality has taken precedence over the traditional religious practice. My submission is this, my lord, Article 40, Article 25 and 26, both are fundamental right. We cannot give precedence to one article, another article. 25 is subject to public order, health, morality, and other parts of part 3 fundamental right, whilst 26 is, my lord, subject to public order, health, and morality. In my submission is this, my lord, one article, both are fundamental right. Well, our constitution forefather has given in this, my lord, we cannot take one article, cannot take precedence of other, my lord. That is my submission, my lord. And one more point. There can be resolving of this when conflict arises. Sometimes overlapping individual rights are overlap with the denominational right. In that case, my lord, balancing effort should be taken and harmonious construction should be taken to balance that. My lord, my submission is the courts are not expert in theology. Therefore, the courts should not determine the religious practice. That is one submission, my lord. Belief and faith have to be existed in India since time immemorial. It's not that after constitution it is there, my lord, but only the constitution has legally enforced there. And it was first in the preamble and then in Article 25 and then in 26, my lord. In Venkatramana Deuri, my lord, these article has read together to make a balance, my lord. And in Sirur Mat case, my lord, it is held that a state can regulate the secular, economic, and administrative activities of the religious institution, while it cannot interfere with the essential core of the religious practices as an internal management, my lord. My lord, rest of the submission made by the learned solicitor, my lord, I accept, my lord.
You want to ask?
Right, my lord.
Yes, what's your good name?
Gauri Subramaniam.
All right. Are you there in the list? Oh, all right, start.
Your Lordships, I'm appearing for an intervener. This is the Bombay Parsi Panchayat. And Your Lordships, you know, all our senior counsels have argued these
Yes.
the matters of law and historical context with great erudition, so I'm not repeating any of it. I have prepared a very short note. At the end of that note, I'm not going through the note at all, but at the end of the note, I've also prepared a flow chart, which I'm hoping would be of some assistance to your Lordships. It traces how a state action can be, how you can actually analyze a state action with regard to denominational rights and religious freedom. I only wish to make 3 very short points. The first is, your Lordship, specifically in the context of the Parsi matters before you, empathy is very important. There is an emotional cost being paid in this particular set of circumstances, but it cannot blur the constitutional boundary between religion and regulation and religious autonomy. Secondly, what may appear as a narrow accommodation today risks becoming a template for incremental constitutional erosion in the future. And thirdly, if individual or even a group of individuals, as in this case and in many others, if an individual's hardship becomes the governing metric, then every denominational boundary becomes negotiable, and then Article 26 risks being reduced to just a case-by-case exception. Lordships, my flowchart is right at the back. Right.
Thank you.
You are very precise.
Very good.
Appreciate it.
Exactly, directly on the point.
Yes.
Yes, please, yes.
Honorable Chief Justice and the companion.
You need to address us.
Yes.
Now you know you are.
My humble submission
Yes.
is regarding the 3 aspects.
Yes.
One is this constitutes the morality, constitutional morality and societal morality. Societal morality.
Sir.
Societal morality can be there, but there cannot be constitutional morality like
Yes.
that when we interpret the constitutional morality, it will lead to many multiplicity of litigations like that on the basis of principle of morality. Second thing, that any sort of judge of the thing which is called the denomination. The denomination is particular aspect of one religion which is specific to one state. It is not comprising of the entire state. So connoting religious denomination for a particular state is not an entirety to maintain that the Hindu religion is having an overall aspect of that. Third thing, my lordship, that is related to subject to public order, health and morality. Now, I just suggestive in nature that there has to be a non-discrimination is there subject to non-discrimination and antithetical to the rules which is mentioned, articles mentioned in 14, 15, 19 and 21. That should be there, the interpretation of the review. And that is my humble submission. Thanks for patient listening, my lordship. Thank you.
Please. My lords, my apologies. I understand your lordships have reached saturation point and looking forward for them to start. I will confine my submissions to just one limited aspect, my lords.
There
Which
is
is the
throw bouncer or hit the bouncer, that's all.
very well, my lords. I'm appearing in IA number 99340. I'm confining my submissions on just one aspect, which is the subjection of Article 26 to Article 25.2. Now, my lords, in my submission, Article 25.2 is inapplicable to 26. And I say so for the following reasons, my lords. Lords, at the outset, if one were to compare the language of the two articles as also the constitutional debates that have happened, it is evident that the framers wanted to vest superior rights in religious denominations. They wanted to treat them separately. And this is so because religious denominations historically have been a closed set, private, exclusive in nature, and nobody could claim as a matter of right the membership should be extended to them. Now, my lords, more importantly, the language in which 26 and 25 are couched, if one was to juxtapose the two, it is evident they contain express and implicit indicators that 26 was supposed to be immune from 25.2. And I say so for the following reasons, my lords. Firstly, your lordships have noted that there is a subject to clause in 25.1, which subjects it to other parts of part 3. Now, 25.1 will obviously be subject to 26 as well. Similarly, my lords, the subject to clause is absent, is conspicuous by its absence in 26. And your lordships have noted that. Your lordships have also seen the subcommittee report on fundamental rights. The original formulation contained that clause, that they were to be, the rights of religious denominations were to be read consistently with the provisions of the chapter. But in the subsequent iterations, that phrase was dropped. And for good reason, my lords, because the framers had the foresight to not frame 26 in a manner which would lead to a contradiction in terms. It can't be that 25.1 is subject to 26, but 26 is also subject to 25. That could not have been the scenario, my lords. Thirdly, my lords, 25.2 begins with the phrase, nothing in this article, so it is evident that it is confined, the operation, the regulatory powers of the state are confined to 25.1 itself. Fourthly, and now I draw your lordship's attention to the latter part of 25.2b. It says throwing open of Hindu religious institutions of public character. Now, as I alluded to earlier, there is no public character. Historically, they've been a closed, the religious denominations have been a closed set. And most importantly, my lords, a reference to Hindu religious institutions by virtue of explanation 2 covers Sikh, Jain, and Buddhist religious institutions as well. Now, please see the consequence of applying 25.2b to 26. Hindu, Sikh, Jain, Buddhist religious denominations get covered, but Islamic, Zoroastrian, Christian, etc. religious denominations are excluded, so that it has a discriminatory impact on other religious denominations.
There is no exclusion as such.
That's right.
In other religions, there is no exclusion.
No, but
specific to Hindu religion. That is why the constitution framers were conscious of the fact that Hindu temples could not exclude, particularly the depressed classes, as they were called earlier.
So I'm not suggesting for a moment that 17, 23, 24 will also not apply. Those are the only caveats.
See, this is something depressed classes, you can say depressed caste. Such a thing, caste system is not there in other religions. So why should they write about other religions in the article?
Your leadership, that may not be true.
They are conscious of the reality of the Hindu society.
That may not be true. Even in Islam, there have been divisions within different sects of Islam. But without that, I'm confining my submissions to first principles.
It's only applicable.
I'm confining my submissions to first principles. If your lordships were to read explanation 2 in the text, in the language in which it is couched, it is confined to Sikh, Buddhist, and Jain religious institutions. So if it were to apply to 26, it would lead to a discriminatory application of that provision. And in my respectful submission, no such interpretation should be given to 25.2b, my lords.
Thank you.
My lords, just 2 more points, my lords. And my lords,
quickly, please.
So, yes, my lords. In fact, I'll skip the second one, just the last point, and I'm taking sustenance from what Justice Bagchi had said the other day, that 26 is a special provision. It is carved out from 25.2. I'm pressing into service the doctrine of generalia specialibus non derogant. Special excludes the general, and in my respectful submission, it will not apply to 26 laws. Lords, I'm very grateful for the opportunity.
Thank you.
With your lordship's permission.
आपसे और उससे वो बैठे हैं हमारे बॉम्बे वाले साहब, दोनों से बाद में निपटूंगा. Because we are not sure whether you want to argue this side or this side. You are definitely arguing this side. And then wait. Wait for 5 minutes. Yes, yes.
My lord, the prism through which, my lords, one looks at, my lord, 25 and 26. If that first expression in Article 25 would hold the key, is the first submission, and that is the right to conscience. Because if we understand, my lord, the right to conscience, my lords, within its operational sphere, then probably 25-26 represents the layered form of that right to conscience, including even the sect. So, my lords, it is in that context, my lords, that I open it. Freedom of conscience denotes, my lords, I'm coming straight to 1A, my lords, having explained, my lords, the first segment of it. The freedom of conscience denotes the right to lead a life as guided by the thought process of the inner self. And my lords, it need not be always be rational. The canons of rationality may not be applicable. And that is why it takes the form of beliefs and the external manifestations of those conscience, the rituals, performances, etc. When two or more individuals, my lord, share that common conscience, then that evolves as the conscience of either a sect, cult, group, or a religious community. So that takes me to 1D, my lords. 1C, sorry. The freedom of conscience of an individual thus encompasses the freedom to follow the personal conscience in his personal space. Now, that personal space is very important. 2, the freedom to be distinct and to dissent, even in a collective forum. That is the freedom to distinct and dissent, my lords, even in a collective forum, including, my lords, probably a religion. The third is the freedom to lead a life governed by the uniform or the shared conscience of the collective forum as its member. So that takes us, my lords, to the concept that as far as religion is concerned, then the worship, beliefs, observances, I'm coming straight to 2, my lords. I need not trouble your lordships with 1D. Includes now the rituals, worships, etc., which are all, my lords, the external manifestations of that conscience, would necessarily come as a package, including the forbearance, the restraints, the injunctions associated with it. Then, my lords, Article 25 by itself determines the contours of application of the right of equality. Because the general notions of equality is there, my lords, Article 14, 15, etc. It gets a specific form in Article 16. And similarly, it gets a specific form in Article 25. So you look at Article 14 through the prism of Article 25 rather than the vice versa. Then, my lords, if so, in the context of Article 25, the right of equality does not take within its fold the right to profess, practice, and propagate religion in variance from the manner in which it is professed by either the religion or the sect. And that is the key to understanding that sect or denomination, even in the context of 25. Article 15.2, 15.4, and 16.5, my lords, are pointers to this. Because, my lords, 15.2, it actually avoids, it does not provide an unbridled access to the temple. While, my lords, the framers were very sure of what other public place should that access, unbridled access, be provided to. There was no such restriction in 15.2. Similarly, my lords, Article 16.5 as a pointer that, my lords, as far as the appointment of any office is concerned, for example, my lord, Alcheka, etc., that is recognized by 16.5 itself. And as far as a belief, which is the outcome of conscience, need not, my lords, appeal to rationality. Then, my lords, I come to even a single temple could constitute a class by itself. That depends on the form of the deity and the variable form of the deity. Chidambaram, we have an example where, my lord, the idol, my lords, has no shape. I just leave it at that, not quoting, my lord, further examples. Then, my lords, as far as the seventh proposition is concerned, at page 3, my lords. Article 25, my lords, when an individual, Article 25
as well as 26, my lords, is linked through this umbilical cord of conscience. Because unless, my lord, the right to profess, propagate, and practice that religion is conferred, probably at some point of time, the sect or the denomination may lose its distinctive identity and it may be rendered to oblivion. So that is, my lord, that link. Because what you practice in the 26 is nothing else but the conscience of that sect and its external manifestations.
Then Article 25 will apply to Article 26.
Yes, my lord. Yes, Article 25, my lords, and Article 25 would be.
Come along with the,
Yes, my lord.
with the restriction imposed under 25(1) and 25(2).
My lord, there it will be a balanced approach.
Either you go this way or that way. You can't say take a bite here, bite there.
No, no, I'm not saying that, my lords. I'm not stretching it to that extent.
You say that the rights under flows under Article 25 to Article 26.
Right.
Then liability also will come.
My lord, naturally, but liability under 25(2)(b), my lords, to the extent 25(2)(b) is there my answer would be only, it would serve as a balancing act, my lords. It would be a balancing act, not one above the other. I'm not placing 26(b) above, my lords, 25, because it complements each other is my submission.
Anything else you guess? Anything?
My lords, I've given, my lords, at para 10.
Yes, yes.
The judicial review, the counters of judicial review. My lords, I leave it at that. The last point, your lordships may just note, para 13, because Mahendran's judgment, my lords, the evidence was taken. Can, my lords, a subsequent writ petition without the factual basis unsettle a judgment which has become final is something which your lordships consider. Obliged, my lords.
Thank you. Thank you, sir. Thank you. First, that lady should argue.
Please, Lordship. Lordship, may I seek indulgence to circulate my
Yes,
4
take
5
two mics.
page submissions?
Take 2 mics with full voice.
Please, Lordship.
Yes, please. Go ahead.
Lordship, this case is not about gender equality in the abstract, but about the limits of judicial oversight over religious autonomy under Article 25 and 26. In our submissions, that majority judgment in Sabrimala erroneously replaced the essential religious practice with a modern rationality test which exceeds the correct jurisdiction, Lordship. With this backdrop, Lordship, kindly come to page 2 of my submission that courts cannot judge rationality of religious faith. The scope of judicial review does not extend to evaluating the reasonableness, rationality of a religious belief or practice. This court inquiry must cease once it is satisfied that belief is genuine and not a pretense. This honorable court in 5 judges judgment, M. Siddiqui, Ramjan Bhumi, this paragraph is quoted. Now, Lordship, kindly come to page 5 straightway, para 5. This is harmony of rights. Lordship, no right is superior to another. So this is majority judgment. Treats Article 14 as an overriding constitutional norm capable of defeating the protection afforded by Article 25 and 26. Whenever the religious practice involves a distinction, this reading is irreconcilable with the 9 judges Constitution Bench in Ahmedabad, St. Xavier College Society, so-and-so. Para 75 is quoted here in below, Lordship. So now my submission would be, Lordship, this 9-judge bench must accordingly restore the original constitution equilibrium. This is my submission, Lordship.
Thank you, Bharti. Thank you. Thank you. Thank you very much.
Grateful, Lord.
Any other young lady interested to argue? Please come forward. Anyone? Otherwise, yes, you start.
Yes, my lord. No, I'm appearing with one of the intervener. My application
If
number.
any woman lawyer, any young lady lawyer wants to argue, please come forward. We will accommodate. You start meanwhile. Yes.
My application number is 88066 of 2026. My lord, I am proposing 6 propositions, my lord. The first one, proposition 1 is reconceptualization of the religious denomination, my lord. So it is the devotee, if he wants to pray a deity, he will have some devotional makeup so that he will think about the deity and he will pray for him. So the moment when he does that, a group of that makeup, where we can say that they consider them as independent spiritual fraternity, where I have dealt with that, my lord, in my written submissions as well. And next aspect is, if in case, if this honorable court feels that essential religious practice is necessary and required, they should follow a certain aspects which I call it as a spiritual physics, which are called as the agamic tenets or any tantric way of worship. So these things has to be tested, my lord. And the another aspect is the bar against institutional syncretism. This is one which I want to highlight, my lord. So thing is, under Article 25, an individual is having a right to practice their religion, and they can practice multiple religions, and even they can mix up and they can do that. But that mix up should not be brought into this denomination. So the moment you enter into the temple, you have to adhere to those principles and practices with respect to the temple. So, and another aspect relating to denomination, I'll come back again, my lord. When we consider this Shaivism, Vaishnavism, all these temples as denominations, so the moment in each temple, Krishna is considered as Radha Krishna and as well as Rukmini Krishna. So all these temples, they fall under the category of section thereof. So simply where we cannot say that, see, Hinduism is a denomination and where we should not give a static test. Even, my lord, in my written submissions, which that I have handed it over, where I have given a definition.
That we will see, please finish, because we have not asked for time, we have adjusted you.
Yes, my lord. And next thing is proposition number 4. I'm coming quickly, I'm wrapping up now. So what is the state's power under 25(2)? So under 25(2), according to me, it is only with respect to financial administration and as well as other secular aspects. It means earlier there are certain temples which were not managed by anybody. So in those circumstances, the state has stepped in and it has taken over as a custodian. It doesn't mean that the state owns the temple. So what state can do? State can legislate it and state can take care of the temple.
All right, next.
So next point is, I have proposed one test with respect to the morality. Morality, no one has dealt with this. No, my lord.
Next.
The thing is, what is morality? This is what I just wanted to highlight, my lord. So if we see from the lens of 25, there are two aspects are there. One is the morality with respect to the individual towards the religion and as well as towards the public. So with respect to from his activities, he cannot create any kind of distress towards the society. And another one is 25 with respect to the impersonification. There are certain godheads are there. There are a few more clerics are there, which they say that I am the incarnation of God. So they should not bring disgrace to that specific denomination. And to that extent, where the Maharaja Libel case is there, my lord, where I have given it my written submissions, where they have dealt, a specific line is there. What is not correct in theology, it is not right in morality.
All right, thank you.
So one more aspect, my lord. And with respect to 26, my lord, there is one judgment called Sheshayengar. What they have held is, a denomination, they can practice, they can conduct the practice at a private area, but it should not disturb the neighbors. This is again 1880 judgment, my lord. And next aspect is, as your lordships has pointed out, if there is any threat or harm, so do we have a jurisdiction? Yes, my lord. As a parents party, the state can step in. This is one way of looking at it. Parents party jurisdiction where they can step in and they can curb those practices.
Thank you.
And my written submissions, my lord, where I have given it, I just give the page number, my lord. It is volume 1.2, 714 to 746, my lord.
Thank you.
Thank you.
Lord, I appear.
First tell you,
Yes, my lord. Just 3 points I'll conclude with that, my lord. I appear in IA 91810.
you please tell us have you given your name in the list?
My lord?
Have you given your name earlier?
My lord, yes, my lord, I had given, my lord. My lord, my name is Arvind Srivatsa. My name is there in the original list also as serial number 45. My lord, I appear in IA 91810 of 26. My written submissions are in volume 1.1, page number, my lord, 848.
Yeah.
My lord, I'll not repeat what has already been argued. Just three propositions I'll place, my lord. First submission, my lord, is on the scope of Article 25(1). There are three parts to 25(1) which your lords have already heard. One is on my lord's conscience. The other is profess. These two are internal absolute rights. My lord, on propagate and practice, my lord, that will be subject to the restrictions of the language in 25 itself. 26, on the other hand, my lord, contains no restriction on subject to Part 3 rights. Therefore, if, my lord, there is an apparent conflict between 25(1) and 26, 25(1) must yield and 26 will play over 25, my lord. And 26, my lord, is subject only to the restrictions of, my lord's, morality, public order and health that are available in the language of the statute itself. Therefore, my lords, insofar as 25(1) and 26, my humble submission is they are different constitutional spheres, and my lord, that they are different constitutional functions. One is on right of individual, the other is on, my lord, the management by the institution itself. My lord, and the submissions on, my lords, Ratilal's case and Shirur Mat, I'll not repeat. The only last point that I'll make is on Devaru. My lord, submissions were made on Devaru. In fact, questions were put by this honorable bench also. Lord, my endeavor is to say that Devaru should be read in the context of Article 17 alone. My lord, the concluding paragraph at page 248 of volume 5, my lord, this honorable court was pleased to already note it, which is Article 26b must be read subject to 25(2)b. My lord, this, my endeavor is to say, kindly read this in the context of 17 alone, because what the court was dealing with on the facts of that case was caste bias exclusion of entry into the temple, not anything else. My lord, therefore, the finding that it is subject, my lord, it is beyond 26 itself. My lords, I would request a lordship to kindly reconsider and only restrict to 17. Not only one other fact on, my lords, statutes that are there, two statutes, which is the Tamil Nadu HRNC, the Hindu Religious Endowments Act, and the Karnataka Act in sections 107 and 69. Both of these provisions, my lord, specifically refer to that nothing in the act will, my lords, nothing in this act shall, save as otherwise provided for in 25(2), be deemed to confer any power or impose any duty in contravention of rights conferred to religious denominations under 26. So this 26 being on a higher pedestal is recognized in other two statutes. I just wanted to place it before. I'm grateful, my lords.
Thank you. Thank
Grateful.
you. Thank you very much.
May it please, my lords. I'll just take 2 minutes, my lords. My submissions, I appear in IA 84798. My submissions are on record.
What's your name?
Akshay Nagarajan, my lords. My name is not there in this list, but I have given my submissions around record.
First, let them finish, those who have earlier. What's your good name?
Sanand Ramakrishnan.
Please, Sanad, you are there.
Yes.
Please argue.
I appear in item 901.29. I appear in review petition, diary number 9135 for the Kerala Brahmana Sabha.
Argue that we will find out whom you are representing. Don't worry.
No, my lords, I will be only briefly touching upon issues number 2 and 7. Issue number 2, of course, relates to interplay between 25 and 26, and 7 relates to whether a person not belonging to the denomination can question. That's coming to interplay. Both articles 25 and 26 are subject to public order, health, and morality. However, 25 is further subject to other rights in part 3, as also including 26. Article 26, on the other hand, does not have such a limitation. Typically, these rights are conferred on non-state actors. In case of infringement of this right by legislation or state action, a constitutional court can be enforced directly, and there is no difficulty. It can be the grievance can be redressed. Difficulty arises in cases where there is no state action or legislation, and the individual asserts Article 25 rights and alleges violation by denomination, and the denomination in turn asserts its own fundamental rights under 26, denying the allegation. So there is a dispute between two non-state actors, each asserting fundamental rights. In this situation, Article 25 can be said to be subordinate to Article 26, as Article 25 is subject to other Article 3 rights, including 26. This scenario with non-state actors asserting competing fundamental rights comes within the classic scenario of horizontal enforcement of fundamental rights. In Puttaswamy, this court has held that privacy is both a civil right and a constitutional right. If there is a peeping Tom neighbor, I can approach the civil court, get an injunction. And if the peeping Tom is the state itself, then I can approach the constitutional court and get my right protected. Therefore, the manner in which I enforce my right, whether it is civil or constitutional, is well settled. In Kaushal Kishore, the court considered whether fundamental right under 19 and 21 can be horizontally enforced. Earlier position was that it cannot be. However, the majority, having regard to the evolution of constitutional law in various other jurisdictions, held that some fundamental rights are horizontally enforceable. The majority judgment also contains a chart at para 73. Article 25 does not figure in that chart. It is conspicuous by its absence. So in a dispute between two non-state actors, there is no scope for an individual to use his or her right under 25 against religious determination or section thereof. The dissent in Kaushal Kishore holds that only 21 and habeas corpus rights and no other fundamental rights are capable of. The reasoning is that necessarily disputed questions of fact arises in such determination. So this dissent that disputed questions of fact cannot be adjudicated in 32 and 226 assumes great significance when an 25 right is pitted against a denominational right. The individual would argue that the practice against the practice, and the denomination would assert long practice. Hence, without getting into the correctness of Kaushal Kishore or the dissent in that case, it can be safely concluded that an individual cannot horizontally enforce a fundamental right under Article 25 against the community or the religious denomination thereof through a constitutional court. If this is the case, the bodies, organizations of the nature referred to in question 7 cannot have any enforceable Article 25 claim before a constitutional court. My written submissions have been placed, settled by P.B. Krishnan, Senior Advocate.
Thank you, Mr. Ramakrishnan. Thank you. Thank you.
My lords.
We'll hear you. Don't worry. What's your good name?
My lords, Rajneesh Kumar Jha.
Rajneesh Kumar Jha. Yes, Mr. Jha. Yes.
My lord.
2 minutes, please.
My lord, have framed
Straight
a
to the point.
substantive question of law on 16th February 2026. My lord, the first question: what is the scope and ambit of right of freedom of religion under Article 25 of the Constitution of India? My lord, as regards Article 25 of the Constitution, which guarantees to every person freedom of conscience and right to freely profess, practice, or propagate any religion, this right is not confined to citizens alone, but covers all persons residing in India. But the right to freedom of religion guaranteed by this article is subject to restrictions, which may be imposed by the state on the grounds of public order, morality, and health. My lord, as regards the second question, what my lord have framed, what is the interplay between the rights of persons under Article 25 of the Constitution of India and rights of the religious denomination under Article 26 of the Constitution of India? My lord, while the Article 25 subclause 1 of the Constitution protects the religious freedom of an individual, Article 26b deals with the collective rights of the religious denomination. While an individual can practice only such rights as are well established and recognized by the community as integral part of his religion, a religious denomination enjoys the independence of determining the rites and ceremonies which shall be essential according to the tenets of that denomination. That while Article 25(1) grants freedom of conscience and the right to profess, practice, and propagate religion, Article 26 can be said to be complementary to it and provides for every religious denomination or any section thereof to exercise the right mentioned therein. This is because Article 26 does not deal with the right of an individual, but is confined to religious denomination. Article 26 refers to a denomination to any religion, whether they belong to majority or minority religion. Just because Article 25 refers to all persons, whether they belong to a majority or minority religion, Article 26 gives the right to majority religious denomination as well as to minority religious denomination to exercise the rights contained therein. My lord, may permit me to read the judgment Sirur Mat, my lord.
No, there is no need to. You
My lord,
point out the paragraph.
The third point, the third question, my lord, whether the rights of religious denomination under Article 26 of the Constitution of India are subject to other provisions of Part 3 of the Constitution of India, apart from the public order, morality, and health. My lord, that while Article 25 extends to all persons, Article 26 is confined to religious denominations. Hence, there is no anomaly in the fact that while the rights under both the Articles 25 and 26 are subject to public order, morality, and health, Article 25 is also subject to other provisions of Part 3. My Lord, while Article 26 is not. My Lord. Question 4th was, well, what is the scope and extent of the word morality under Article 25 and 26 of the Constitution of India, and whether it is meant to include constitutional morality? My Lord, that the concept of constitutional morality refers to moral values as enshrined under the Constitution, necessary to answer the correct meaning of the Constitution and the object behind it. Constitutional morality is, in secular country like ours, gives freedom to practice one's own faith based on the tenets, custom, or usage of the concerned religion. My Lord, as regards 5th question,
Sir,
what is
please
the
don't read, just
scope?
sum up your argument, you have
Yes,
prepared
yes,
it,
my
and
lord.
just tell us what is
My
it
lord,
about.
what question my lord has framed, I'm answering all those questions, my lord.
You just answer it, but don't read it and then tell us now.
My lord, I will.
If you want us to read, we'll read it. No
What is the scope and extent of judicial review, my lord? I have already answered, my lord. What is the meaning of expression of section of Hindu occurring in Article 25(2)(b) of the Constitution of India, my lord? In Article 25(2)(b) of the Constitution of India, the explanation 2 expands the connotation of the word Hindu to include Sikhs, Jains, or Buddhists. But this expansion will not apply to any other provision of the Constitution. Hindu is a comprehensive expression, as the religion itself is, giving the widest freedom to people of all hues, opinions, philosophies, and beliefs to come within its fold. This means that even though the religions of Sikhs, Jains, Buddhists arose out of descent from Hindu religion, for the generality of purposes, those religions should be considered to be different from the Hindu religion. But for the purposes of Article 25(2)(b), they should be considered as part of Hindu religion, and consequently their religious institutions of a public character should be thrown open to all sections of the Hindus instead of being confined to members of their own sects or denominations. My lord, last questions, what my lords have framed, whether a person not belonging to a religious denomination or religious
Available before us.
My lord.
Why are you reading it?
No, my lord, I have prepared it, my lord. I'm sorry.
Read it, we read it.
That we will read.
Read the questions only, give your answers.
My lord, the religious, as regards the religious denominations, my lord, last question was whether a person not belonging to a religious denomination or religious group can question a practice of that religious denomination or religious group by filing a PIL. My lord, the answer is no to mine.
All right, thank you very much, Mr. Jha. Yes, young man. Yes,
Thank you.
Sorry, my lords, I didn't mean to jump the queue. I couldn't give my name in the original list, but my written submissions are on record. They're at volume
What's
1.
your good name?
Akshay Nagarajan.
Huh.
My written submissions are on record at volume 1.2 at page 379. My lords have it. My lords may read it. I supplement Mr. Vaidyanathan, who had appeared in my intervention application. It is the Hindu Dharma Acharya Sabha. They are a conglomeration of 133 sampradayas. They represent Adinams. They represent the Kabir Panthis, the Nagas, and just the diverse conglomerations. My lord, I just have 2 points on the definition of a religious denomination. A lot of learned senior advocates have made submissions. An interpretation was given by learned senior advocate Mr. Vaidyanathan that it should be a sampradaya. Learned senior Dr. Dhawan had said that it should be considered institution specific, which means that any institution which is a religious foundation should be entitled to 26 rights. Learned senior advocate Mr. Deepak had said that it should be a religious association as traceable to Article 19. My lords, in my only point that I would like to canvass is how a religious denomination should not be defined. Over the course of time, my lords, a certain exclusivity and rigidity has been applied in the definition of religious denomination. I will illustrate this point with just one judgment. That is the Adi Visheshwar Kashi Vishwanath Temple versus State of UP. It has not been read. I don't intend to read it. I'll just make a small point on it. A claim was made by the followers of the Shaivite order saying that the law taking over the Kashi Vishwanath temple is violative of Article 26. A question was put whether the followers of Lord Shiva are a Shaivite religious denomination. My lords have been told the threefold test: common organization, spiritual faith, and designated by distinctive name. Here, my lords, peculiarly, the followers of Lord Shiva had lost, this denominational temple had lost on Article 26 on the reasoning that every Hindu believes in Lord Shiva. Therefore, what is so exclusive to you? That way, my lords, in my respectful submission, no Hindu religious group will be entitled to denominational rights. Every Hindu anyway follows every other god in the pantheon of gods. There is no exclusivity to Lord Ganesha. There is no exclusivity to Lord Vishnu. Similarly, my lords, this had happened in the Guruvayur temple judgment also.
So, the same faith, same practice, there can be multiple denominations.
To multiple denominations, my lord. In my respectful submission, to ask a religious denomination to show us how exclusive you are may not be consistent with the manner in which fundamental rights have been interpreted in our constitution. Now, my lords, in my humble submission, I think that kind of exclusivity has been imparted in the Sabarimala judgment also only because they lost denominational status because everyone is allowed in the temple. Hindus, Christians, Muslims, everyone. My lords, that in my respectful submission would be unique to that temple. That everyone is allowed is something to be preserved. Therefore, my lords, a submission was also made that the judgment in SP Mittal denying the followers of Aurobindo denominational status should be overruled. My lords, I would respectfully adopt that view.
Thank you.
I would also respectfully request my lords to revisit Adi Visheshwar Kashi Vishwanath Temple, 1997, 4 SCC 606. That,
Is the citation?
my lords, it is 1997, 6 SCC 406.
06.
And my lord, similarly, the followers of Lord Krishna in the Guruvayur temple case, they were also denied denominational status because anyway, every Hindu believes in Lord Krishna. What is so unique about this? That may not be the correct test, my lords. And I'll just make one final point and I leave it at that. My lords, a lot has been said on the interplay of Article 26(2)(b) second part and Article 25. I just want to make a submission on the interplay between Article 25(2)(a) and Article 26. In my respectful submission, my lords, a law throwing open a Hindu temple of a public character may also govern a religious denomination. It may. Venkatamana Devuru holds the field. My lords will have to take a view. Insofar as Article 25(2)(a) is concerned, there is no textual justification to regulate a secular, financial, economic aspect of a religious denomination by a law. In other words, a law made under Article 25(2)(a) can never govern Article 26 institutions. That is because Article 26(c) and (d) already deal with secular aspects.
Why do you say that?
He doesn't say anything about the problem here is you all, everybody trying to think about denomination only into 25. It only speaks about 25 one persons.
But
It
yes.
is incidentally institution will come, denomination will come, B will come, other will come. That's not the objective of the constitution.
My lords,
Problem is our mind is fixated on this and we trying to.
no, my lords, the only thing that there are some state laws that pass.
We understand.
I only admit the submission is that 25(2)(a) cannot be made applicable to a 26 institution.
Small example, suppose there is a temple, they want to have an annual festival, like they have the annual car
The
festival,
car festival, Theru.
chariot, or whatever. You can't block all the roads around the temple. If you start, that is, you see, that
Public
is not-
order, my lord.
that is one is public order, that has nothing to do with the religious activity. You do your religious activity, but not by blocking all the roads.
Yes.
The state can always step in,
The state can, my lords, the state can step in to regulate.
exclusive or you.
I'm only, I'm sorry.
Any activity which is
Once-
not religious in nature, that is the autonomy which is given under Article 26(b) to that, they can decide what is that religious affair or religious practice.
I'm so grateful.
The court cannot sit in judgment over it. That
Yes.
is the right which is created under Article 26(b). Suppose they say we have a particular way of worship in this temple, Suprabhata, etc., etc., etc. That is the autonomy which is given in the manner of worship.
Yes, my lady.
Court cannot sit in judgment and say, no, this cannot be done. That is the idea of Article 26(b).
Yes, my lady.
While exercising that, if you are going to, public order already is there. Apart
Yes.
from that, if a secular activity is also being affected, then the state can step in. There has to be a balance.
My limited submission is only this, that secular activity can be taken care of under Article 26(d). because it is only property rights of a denomination
No,
of.
we understood.
I'm grateful, my lord.
Dr. Vivek, 5 minutes. Only 5 minutes. No, no paper. Don't open. You just argue straight.
Can't block all the city roads and all that.
Lordship, Indian Constitution is not an inert document. It is a living organism, and it takes its effect and the meaning how the Honorable Constitutional Court of this land interprets it. Religious freedom affects every common man, and this common man does not know the complex principles of the law. This is what our constitution makers drafted the Article 25 and 26. In Article 25, the term religion, and in Article 26, the term religious denomination or any section thereof, these are totally three terms, have the different meanings. First, I will say that what will be the religion? There are four types of the religion. First, the religions which are originated in India and have also the denominations in the foreign or any section thereof in the foreign also, like the Hinduism, Sikhism, Jainism, or the Buddhism. Second, the religions which originated in the foreign land and have also their denominations or any section thereof in India also, like as the Christianity or the Islam. Third, the religions which disappeared, that is the religion without followers. Ancient Egyptian religion, Mitharim, there are some religions which in the Isa 1 to 4th century disappeared. Today they are not existed. But even tomorrow, if any individual started to practice them, then he will get the freedom under Article 25(1). And if a group of followers started to profess that, then he will get the freedom under Article 26. Now the fourth type is, in future, there may be a new religion also, and the same case in that also, for the individual also and for the followers also. Now, Lordship, I will say in the short, what is the religious denomination? Religious denomination means a subgroup within a broader religion. We know in Hinduism, like the Shaktis, Vaishnavism, etc. In Christianity, the Catholics, the Baptist, etc. And in the Jainism, the Digambar and Swetambar, and in Islam, Shia, Sunni, etc. Now, our constitution makers did not provide any definition or test of religion or religious denomination. Why? It has three regions. First region, religion is not limited to borders. It has international feature and international presence. We cannot say if the followers of a particular faith are not constituting the religious denomination and the followers of a particular faith constituting a religious denomination. For example, Islam and Christianity originated in foreign. How can we apply any test to a foreign originated thing for its existence? It is also. Second, constitution makers knew that the Hindu religion is the compilation of various religious denominations or any sections thereof. There are various gods, various goddesses, various customs, various traditions, various temples, but all are part of Hindu religion. Third, our constitution makers also knew that in future some atheists may try to destroy and spoil the custom and traditions of any religion. Now, I will say one thing more, like the Hindu go to the Kailash Mansarovar Yatra, because the religion cannot be confined to the borders. It has international feature and international presence. It is the important thing to explain the Article 25 and 26. Now, Lordship, the religious denomination test is not according to the intention of the constitution makers. It is my first proposition. Even a section of any religion, any religious denomination would get freedom under Article 26. Article 26 do not describe that how much followers are necessary to constitute the religious denomination and how many followers are necessary for their section. For example, the Dalai Lama is a political asylum in India.
and he represents the Tibetan Buddhist denomination. A section of that, and he also gets the full religious freedom in the Dharmsala by the Indian government. It is also the reality. And also, like Lordship, there is a Yazidi religion. They are a minority in the somewhere in the northern Iraq, and they follow the peacock god. If tomorrow Indian government give to 10 or 20 families of the Yazidis the political asylum, they are the section of their religious denomination. They will also get the freedom of Article 25(1) and 26 both. Now, Lordship, under Article 26, there is no discrimination in different religious denominations. And also our constitution do not make any category of gods in Hindu religion. In Article 26(v), I will point one thing more. To manage its own affairs in the matter of religion, right to manage includes right to decide their modes of worship. Right to manage also includes who will enter, and right to manage also includes right to express their belief and faith collectively. Now, Lordship, one thing, the essential practice, so far as the essential practice doctrine is concerned, it should not be. Because in Article 25, 2A non-essential practices are already given. But now, Lordship, one thing, I will give the answer one by one in 2 minutes. All the
You almost summed up 1 minute.
Lordship, one thing, please. Lordship, we are waiting since 4 weeks, so please. In Article 26 is not subject to other articles of the Part 3rd, including Article 25. The rights of any individual under Article 25(1) cannot supersede the rights of any religious denomination or any section thereof protected under Article 26. It is right. Now the scope of Article 25(1). All persons are equally entitled for freedom. All persons include citizens and non-citizens both, foreigners visiting India, diplomats living in India, refugees in India, all the categories. Dalai Lama is also political refugee, which I mentioned. That means Article 25(1)(a) also clears that the religion always have the international feature. We cannot restrict it only in India. Scope of Article 26.
That is why it is part of religious tolerance.
Yeah, absolutely, that is it.
What is part of religious tolerance?
Tolerance. And now the scope of Article 26. It is available to the followers of that religion also, which originated in foreign, but its religious denomination or any section thereof is in India, like the Islam or the Christianity. If Islam and Christianity have 2, 4, or the 5 religious denomination. If 50, 30, or the 60 families of that religious denomination are residing in our country, then they will also get the protection of these articles, because we have to emphasis on every word. Any section of thereof is specifically mentioned in that. Now, Lordship, question number 4. It is clear under Article 25 and 20.
Yes.
Under Article 25 and 26, morality does not include constitutional morality. It is correct, because it is discussed, but even then it is not mentioned. Religion, customs, and traditions are also the source of morality. What is morality? Morality includes the high values of life, character, and conduct. Service of mankind is also morality. For example, the Florence Nightingale services to the wounded soldiers in the relief camps during war is also the example of the morality. Like as the William Shakespeare's famous lady character Portia, appeal of mercy in the trial scene of courtroom is also the example of the morality. And also in Hinduism, like as we can say, the Sarve Bhavanta Sukhne, Sarve Santu Niramaya, Sarve Bhadrani Pashyantu Ma Kaschitu Bhag Bhavet. That is the prayer to welfare of all, is also the example of morality. And now in Islam, in Arabic, salam means, Lordship can understand, salam means peace. Yeah, Lordship. Lordship, Lordship, the salam means peace, and Islam means the way to that peace. How to get that peace? There are the five pillars of the Islam: kalma, namaz, roja, zakat, or hajj. I will point out only on zakat. Zakat means charity. That means donation to needy. That is also the morality. Live and let live. Jio or jeene do. It is also the morality, apart from speaking truth, benevolence, etc. Now, Lordship, in judicial review, the constitutional explanation of Article 25 can be done. Besides any state law, concerned with Article 25 is also subject to judicial review. This Honorable Constitutional Court is the custodian of the Constitution, so there can be no limitation on the power of judicial review. It is the inherent power because it is also the basic structure. Now, what is the extent of judicial review? It should be in such a way that the spirit of religious freedom would be maintained. Now, the section of Hindus in Article 25(2)(b) is based on caste. Everyone says, because caste is the integral part of the Hindu religion. It is not gender-based because gender is in every religion, but the caste is only in Hindu religion. Because we have to give the reason why it is so. So that's why. Now, Lordship, question number 7. The belief, faith, and worship. Three things: belief, faith, and worship are protected in preamble. And also in Article 25(1), when we say the concise, the belief and faith and worship in do practice and profess. And in Article 26(b), I also explained, of the Constitution of India. It is not the subject matter of logic and science. So a person not belonging to a religious denomination or religious group cannot question the practice of that religious denomination by filing PR. For example, it may be the question that who has seen the God? That means no God, no religion. But the fact is that the existence of God remains in the belief and faith of the followers. Now, Article 26 is not subject to other provisions of the Part 3rd, including Article 25. We should not make the complex synonyms or the complex analogies to create the problem. We should give the simple reading of the articles. What the Constitution makes all things are written in the 25 and 26 clearly. So far as Article 394 is concerned, authoritative text in Hindi meaning is concerned, it was injected by the 58th Constitutional Amendment Act in 1987. Constitution was written before 1950. Religion is the international feature. It cannot be lots of within 1 minute. I will conclude.
1 minute.
Religion is an international feature, cannot be confined to one nation or one language. Even English has distinction of international language. To understand the original and real meaning, we have to give the effect of English version. So that's why, nothing more. Now, Lord, say one thing. How the rights of deity or ideal protected in the Constitution? Many are said that the Pran Pratishtha ceremony, juristic person, deity eats every day in the form of bhog, or he sleeps every day in the form of Sayan. He is the living entity and also the juristic person established by the court. But the rights of deity is protected by the customs, tradition, priests, and the followers. And the right of these followers are protected by Constitution under Article 25(1) and Article 26. Thus, the rights of deity are indirectly protected by the Constitution. Not directly protected, they are indirectly protected. Because deity will not say anything. The followers will say that how our deity will do something or what the tradition, what the custom wants. Now, Lordship, at last, one thing. In Sabrimala temple case, there is no violation of Article 14, 15, 17, and 25. There is no ground of age in Article 15, and it is last one thing. In Hindu religion, temple is a place of worship. It is not a picnic spot or the tourist place where everyone can go without following the custom or the tradition. For example, a person comes to this honorable court with a prayer or with a request that I want to go the worship place wearing the shoe, or for the midnight visit in the temple, while the custom and tradition are not allowing this. Whether the court will allow? Not at all, Lords.
Yes,
it is.
Thank you, Dr.
Grateful, Lords.
Thank you very much. Thank you. Anyone my lord, is there anyone, Mr. Gaurav Kumar? Anyway, Mr. Sai Shashank? Madam Prachi Bajpayee? We were oh, done, yes, done. And A. Shima also done. Yes. Yes. Always. Now, Mr. Nedampura, you
Yes,
are
my lord.
arguing this side.
Now it is
No,
10.
you are arguing the.
No, for the petitioners, for review petitions. Mine was the first review petition. Mine was the first review petition seeking review of the Sabarimala judgment.
10 minutes.
My lord, now
10 minutes.
I need some time.
Everything in Latin terms?
No, my lord, I will not say a word which others have dealt with. Now, my lord, I am raising certain theoretical issues, fundamental legal issues. Now, my lord, the other day I came across with a judgment in Eminent Colonizers Private Limited. At paragraph 24, it is said, a judgment in rum act as a precedent. And my lord, there are other, it is based on a Latina of the judgments. Number judgment in rum constitute a precedent. What is a judgment in rum? What is a judgment in personam? My lord, these terms have been very widely misunderstood. The Chief Justice, Honorable Chief Justice knows the case of K.S. Varghese. In K.S. Varghese, the dispute was about 3 churches, Kolanjeri, Varikoli, Mannatur. The suit was a representative proceedings. And the judgment, being a representative suit, will bind the parishioners, the trustees, and the 3 churches, Mannatur, Kolanjeri, and Varikoli. And the Justice Arun Misra in his judgment in K.S. Varghese said, since the suit is a representative proceedings, the judgment is one rendered in rum, and that will be applicable to all churches. And what followed was literal revolution in Kerala, literal fight between the 2 Orthodox factions and the Jacobite faction. And all of the judgment in rum is not a judgment, it does not constitute a precedent. What is the distinction between a judgment in rum and in personam? A simple example is in a suit for divorce, where a judgment is, divorce is granted, the judgment is in rum. Where a divorce is declined, the judgment is in personam. So, my lord, the fundamental principle of law that res judicata, you are bound by a judgment, right or wrong. Res judicata pro veritate accipitur. It is founded on 2 principles. Interesto republico ut sit finit litium. In the interest of the republic, there shall be finality of litigation. And second principle, my lord, in public interest. Nemo debet bis vexari pro uno et idem cosa. No man shall be vexed on the same question more than once. So, a erroneous judicial decision, Ulpian said very, one of the words of Ulpian, res judicata facit ex albo nigrum, ex negro album, ex carvo rectum, ex recto garvum. So, a judicial decision can make white the black, black the white, straight the crook, crook the straight. So, a judgment in rum is not binding on the whole world. Now, I am asking you the question, coming to the jurisdiction of this court. Your Lordship, the 9th Constitution bench of this court passed a judgment. And as somebody who believes in basic jurisprudence, I would say that, my lord, your Lordship will not bind me. I am not a party to the proceedings. The doctrine of res inter alios acta, altori, naseri, non debet. So I am not bound by your Lordship's judgment. I will not obey your Lordship's judgment.
Either you argue in English before us, or you will argue in Latin.
No, Lord, I will argue only in English. I will translate.
Yes.
I will translate.
Yes.
So therefore, my lord, the question is, your Lordships, the greatest respect, your Lordships have no jurisdiction to render a judgment in a proceeding which I am not a party at all. Why I say this is because, my lord, if the issue, assume there are believers and there are believers who believes that the restriction is a mere superstition, and there are believers who believe that it's a core of the faith. Assuming that's a conflict, there is no conflict. Assume that there are 2 groups of people. And such a, there was, in which case there is a list. And whether the belief is right or wrong, no court can decide. There's a technical, theoretical reason for that. I'll come to that. Now, if such a dispute is there, whether there is a belief is or not, and if there is a belief and there are two factions, we have different point of view, like in the church case, then such a dispute can be decided only in a representative proceedings. In a suit duly constituted involved under section 92 of the CPC, under Order 1, Rule 8, CPC, their suit is conducted as a representative proceedings, and the judgment acts as a res judicata. It binds all. So therefore, there are two judgments here. The judgment of the 5-judge Constitutional Bench. The other is a judgment of a Kerala High Court in C. Mahendran's case. In my humble submission is, both the judgments are one rendered void ab initio, because those judgments were rendered without notice to the devotees at large. So therefore, now otherwise I would have said Article 32 petition could not have been maintained when there is a judgment which is otherwise binding on all. So the Mahendran judgment is not binding on anybody, because it was on a writ jurisdiction, it was on a PIL. Now the question is, we talk about judicial review. I certainly, my lord, I adore the concept of judicial review. But the foundation of judicial review is the principle. In many other countries, America and all the Commonwealth countries, the concept of judicial review is very much there. But the validity of the judgment is solely founded on the fact that the judgments of the court, my lord, receive so much of respect and adoration, and it is accepted out of reverence, not because it is res judicata. I take a drop of water. Now, it is therefore judicial. When I challenge a statute before your lordships, and your lordship declare this statutory provision or statutory instrument unconstitutional, the people of this country accept it out of reverence. It is not because it is binding on those who are not parties before the court as res judicata. Now, the fundamental principle is I am not bound by a judgment of which I am not a party at all. The reason is it is against the first principles of natural justice. In a proceedings where I had no opportunity to address the court, adduce evidence.
Please go to the next point. We have understood your point.
Now the second ask, yes. So therefore, my submission is the judgment in Shabarimala case, 5-judge Constitution judgment is one rendered void ab initio, and it is liable to be recalled, reviewed ex debito justitio. And that concept is, my lord, when I learned first thing about certiorari is, my lord, where certiorari is, where an order of a tribunal is without jurisdiction, then writ of certiorari is granted. That is I learned in 79. Ex debito justitio. So therefore, the review petition is liable to be allowed. I am only speaking about Shabarimala, for which alone I am authorized, as one which is rendered void ab initio. The second proposition, I will be very brief. The second proposition I have here before me, the lordship's judgment. When my lord, yes,
please have water. You missed to know that in your water bottle there was no water. It was empty. Honorable
yes, there was no water. Yes.
Water bottle. Please have it.
I'm grateful to your lordships. So Tirumurthy, Fragrances Private Limited, where my lords, Justice Suryakant, Chief Justice, and Justice M.N. Suresh, Sundaresh, both were parties. And there their lordships have taken a view that numerical strength is the determinative factor. My lord, I have a right to dissent. My lord, what is a precedent? Is a principle which a court of competent jurisdiction, superior court has evolved, where none existed, and or where for a resolution of issue which was before it, or a principle which has been repeatedly reaffirmed. So precedential value of a judgment is the principle and not the numbers. And it is in contrast with the res judicata. Res judicata, my lord, a bench of 5 judges calls an innocent man guilty of murder, sentenced him to death. He is innocent, but because the court has found him guilty, he will be hanged. So therefore, an erroneous decision, right or wrong, is binding. And where the matter is, if there is a division of the bench, what is determinative is the relative strength, the majority, numerical strength. That is what is applicable to res judicata. And when it comes to the question of, my lord, the precedent, the number does not matter. Now, this in all over the world, except in India, and it has been noted in paragraph 44 in Andule's case, that we follow a new jurisprudence where the presidential value of a judgment is determined based on the strength of the bench and interstate strength of the within the bench. So therefore, that is absolutely incorrect. Why I emphasize on this, my lord, in all humility, I consider many judgments, the greatest respect of this court, constitutional judgments are with fundamentally wrong. The first judgment in Keshavananda Bharati, in 3 sentences, my lord, I can convince your lordship how flawed it is.
We are not on
No, because Keshavananda Bharati is referred to in many, only 3 sentences only, my lord. These are fundamental things, Keshavananda Bharati's case.
Please confine to the issues.
Yeah, I am only on this issue. Only on this. I am only saying 3 sentences. The world is interested to know 3 sentences why the Keshavananda Bharati judgment is flawed. Before Keshavananda Bharati, my lord, ibi just remedy, right remedy forum. When I come before your lordship would ask, Dhanbara, why are you here? I will have to plead violation of fundamental rights. After Keshavananda Bharati, I would come to the court and say, my lords, none of my fundamental rights are infringed. And what the basis structure? Because of the reference to the judgment of the Keshavananda Bharati, your lordship will not ask me if the basis structure has crushed. How come it mattered to you if none of your rights are infringed? So therefore, my lordship, Keshavananda Bharati opened the gates of this court for, my lord, busybodies to come, for somebody to come to approach this court that none of my rights are infringed and without complaining any violation of fundamental rights. My lord, is a scenario which is most unfortunate. And my lord, in D. Colo's case, the Nigerian Constitution Bench tried to undo some of the mischief arising out of the Keshavananda Bharati by saying that fundamental rights is also a basis structure.
We understood that. Next point, Mr. Nehru.
No, yes, no, my lord, now, my lord, the whole question is, PIL. PIL, my lord, pro bono litigation, absolutely legal. Somebody is in jail. I take up his case. The A in jail, he is the petitioner, not me. Maybe Matthew Numbara versus Union of India, maybe the title, but the man in jail, the under trial, whose cause I take up, he is the petitioner. Therefore, that is constitution, there is a person aggrieved, he is entitled to remedies, and there is a forum, right remedy forum. On the contrary, the public interest litigation is all about stepping in the shoes of the Attorney General, who is the sole representative of the public interest, sole custodian of the public interest, parents patriae. So every PIL petitioner is a Attorney General. And my lord, there are some cases PIL has done some good. But today I raise this issue because PIL has become a great mischief. Issues concerning the public at large are decided behind their back. Many instances, because when I raised this issue, I raised the cause of the merely 4 or 5 lakhs of slum dwellers in Bombay. Your lordship may not, Krishna's book of the bench speaks about a PIL instituted by Bombay Environmental Action Group. Behind the back with the slum dwellers, an order came to be passed to demolish all their shanties. And my lord, 4 lakh shanties were demolished. It happened in Bombay. I came to Bombay as a station lawyer. My lord, all ex parte orders were passed directing in these slums to be demolished. Committees were constituted, appointing the chief secretary, police commissioner, and to give report to the court. And my lord, any number of petitions were filed. It was never received. One finally, I took, my lord, I believe in constitution means, not democratic means. But as a last resort, I organized slum dwellers ladies in 5 buses, made them enter one by one to the courtroom of Justice Oka. And that was the end of the torture of the
We understood that.
demolition of the slumdog list. My lord, therefore, my lord, I am not saying that, my lord, your lordship should absolutely shut your doors to the PIL, my lord, if something good. But PIL is something to be kept in mind is completely without jurisdiction. And my lord, all that, if somebody comes with a, my lord, seeking any of this in the nature of mandamus, quick time proceedings, where a public authority has failed to discharge its function, certainly yes, for which we don't have to say it is a PAL. Now, my lord, my lord, I may be forgiven. My lord, I'm a critic. I'm a bona fide critic. I've been working for last 20 years for judicial reforms. My lord, this is sad that, my lord, SLPs are dismissed in a few seconds. We need to hear the common litigant. Common litigant, now my lord, this bench, my lord, I'm not blaming anybody, my lord. With the folded hands only, I'm saying this. No, my lord, no, only one sentence.
Can ask you to
Only
stop.
five courts were closed.
The way you are.
No, 5 courts were closed.
Stop criticism outside the court halls.
So, my lord, so many.
Concentrate on the subject or
Yes,
close your arguments. This is not a forum for all this.
Yes, my lord. Yes, my lord. Now coming to Ayyappa, coming to Ayyappa, my lord. These are all things. The grievance of the people. My lord, with the folded hands only. These are all the.
You have made enough real for social media.
My lord. Now the coming to the Ayyappa, Lord Ayyappa, my lord. Now, my lord, now there are certain religious beliefs which may, in a sense, be violative of the equality clause of the Constitution. I'm a Christian. Syrian Christian. Many practices we follow are discriminatory of women. And there the court cannot step in. Any reform has to come. The reform has to come from within. And then, my lord, then, my lord, tomorrow the Ayyappa devotees, ladies, come forward and said that this shrine should be open to us. Certainly, my lord, that will happen. And all that I know that, my lord, not a single devotee exists. All the lady devotees, my Ayyappa Devotees Association, my clients are all ladies. They all believe that this is the ordained of Lord Ayyappa. And, my lord, it is the duty of the court, my lord, to protect their belief. Until and unless, and in so long as there is no counter argument that until and unless at least a few women come up and say, yes, we want to go to Lord Ayyappa, and it violates our fundamental rights. Yes.
Can I have 2 minutes, my lord? My lord, not more than 2 minutes. The temples in Kerala are different from temples in other parts of the country. There is a mythological story behind that. Parashurama threw an axe from Gokarna, which fell near Kanyakumari, and this land came to be called as Kerala. My lord, he had 2 tasks before him. One, to make the land fertile, and another, to make the land holy. To make it fertile, to desalinate that land, my lord, he invoked the blessings of Vasuki, the serpent king, who spit venom and made it fertile. And the other aspect is, to make the land holy, he consecrated 108 Shiva temples and 108 Devi temples. My lord, as far as the Kerala temples are concerned, Chaitanyam is infused in it. Divinity is not inborn. You can close down a Balaji temple in Tirupati or Sri Rama temple in Ayodhya for a week and reopen it thereafter. Divinity will not be lost. But as far as Kerala temples are concerned, unless the religious practices and tantric rituals are continued daily, my lord, the divinity will diminish. So that aspect of the matter may kindly be borne in mind.
May I submit, my lord, the argument notes? Okay.
इसको छोड़ो तो बोल respondent side. So to commence the argument on behalf of respondents. Madam Indra, you will start tomorrow.